right? Once there is a judgment against this corporation, whatever assets the corporation owns, this accounts receivable, inventory, intellectual property, the lawsuit can reach. So why is this client kicking himself now? He's kicking himself now because he could have very easily done this. What is this? This meaning that you have an entity that is operating the business, and it's usually the operating entity that is exposed to risk. It is exposed to lawsuits by employees. It is exposed to product liability claims by customers. It is exposed by lawsuits by vendors, right? And government agencies and so forth. Primarily, the risk exposure lies with the operating entity. If that is the case, why would we want this operating entity to own the assets? That is silly. Why can't some other entity own the inventory and then consign it to the operating entity? Why can't some other entity own the real estate that the business is in and then lease that real estate to the operating business? Why can't some other entity own all of the intellectual property and then license it to the operating entity? So this way, when there is a lawsuit against the operating entity, all of these valuable assets are not owned by this entity. They're owned by separate entities. Now, is this an example of a bulletproof asset protection structure? Of course not. Right? The plaintiff may be able to argue substantive aggregation and try to pursue all of these assets directly. Substantive aggregation is sort of like a sideways piercing of the corporate veil, trying to aggregate the ownership of the entities and combine them into one, commonly done in bankruptcy. But maybe this works. Very often, actually, this works. Right? Not a difficult structure to set up. I mean, how expensive is it to set up, let's say, a separate LLC to hold the client's valuable intellectual property and then have a licensing agreement running back to the operating entity? Not very difficult to do. Most businesses do not have the structure. And the reason for that is that they set up the original corporate structure when the business was in its infancy. They didn't have money for fancy structures and fancy lawyers, right? They just wanted to get up and off the ground, and they were spending all of their money on marketing and research and what have you. Now that the business is more mature, there is more money in it, there is more risk exposure. Now they can set up the structure, but they haven't. Why? Inertia, right? The same inertia as to why individuals don't do asset protection. We haven't faced a major lawsuit. We're not going to think about this right now. This happens to other companies. It hasn't happened to us. So this is a structure that I think everyone should contemplate if you are representing a business that has some product, maybe product liability exposure or any sort of risk exposure, employee exposure, and the business also happens to have some valuable assets. Okay, let's move on. So I've been talking for about an hour, exactly an hour. So we'll go for another 20 minutes approximately, and then I will open it up for the Q&A. And as a reminder, if you want to pose questions or email questions, I will answer them at the conclusion of the presentation. Just please make the questions related to the presentation if you can, and make sure that the questions are not too fact specific. Okay, so this is sort of a related topic. Let's say that we have a business today, and this business is a corporation, and let's say that our client is a very, very poor driver. And we're afraid that he is going to run over a troop of pedestrians, and he will get sued, and then those pedestrians will take from him his corporate shares. Right? Corporate shares are attachable, and once they get the corporate shares, all of the entire corporate business, all of it, it's gone. What can we do to change that result? Well, one possible answer is we can liquidate the corporation, take all the assets out, and then put the assets into, let's say, a limited liability company or a limited partnership and get the charging order protection. That's certainly possible to do, but that may have very undesirable tax consequences if this corporation has assets with built-in gains. What else may we be able to do? we may be able to simply place an LLC holding company on top of the corporation, meaning transfer corporate shares into an LLC. This LLC may be a disregarded entity, so it will not even blow an S election, and now the client owns LLC interests instead of corporate stock. That might work. The structure that we often use, which I think is a very interesting structure, is to take this existing corporation and convert it into a limited liability company. Right? And under the law of pretty much any and every state, you can convert a corporation into a limited liability company, or vice versa. But in our case, we want to go from corporation to LLC. And once the corporation becomes an LLC under state law, we have the benefit of the charging order protection. And what's interesting is that from a tax standpoint, when we do this conversion, we can have a limited liability company that continues to be taxed as a corporation. You can even make an S election if you want to, which means that there are no tax consequences in the conversion. It's treated as what's known as an F reorganization. It's a very interesting way of going from a corporation into an LLC. Okay, let's move on. Let's move on to trusts. Now, you would think that a trust is a subject that should be discussed only when we are engaging in asset protection planning for a natural person, right, for an individual. And I think commonly that is certainly true. Trusts are, 99% of the time probably used for individual debtors, right? Trust is something you do for your estate planning, for your estate tax planning, and very often for asset protection planning for individual debtors. And I'll explain why in a second. But can a trust be used to protect the assets of a business entity like a corporation or an LLC or a partnership? And turns out that the answer is yes. A trust can be used, to protect the assets of a business entity. And I actually have a case like this right now where we are doing that. We are using a trust to protect the assets of a business entity. And the reason why we can use a trust for a business entity is because anyone, or anything, I guess, can be a settlor of a trust, can establish a trust. It does not need to be an individual. Most commonly, it is an individual, because that's the context usually where we see trust being used. But a trust can actually be established by a legal entity. Trust can be settled by a corporation. Trust can be settled by an LLC. And once this, let's say, the corporation settles the trust, meaning it transfers its assets to the trust will provide the corporation the same asset protection benefits that it would provide to an individual. So let's take a look at what sort of asset protection benefits a trust would provide to either to a corporate debtor or to an individual debtor. So first of all, what sort of a trust are we talking about? It has to be an irrevocable trust. What does that mean, an irrevocable trust? The trusts that you most commonly see out there in the world are what are called living trusts, right? They're the most common garden variety estate planning trust, the living trust. And the reason that we do not use living trusts in asset protection is because they are revocable. The revocable means the following. Revocable does not mean that someone has the power to terminate the trust. The power to terminate is separate and distinct from the power to revoke the trust. Revocable means that the settlor of the trust, the person who initially funded the trust, has retained the ability to get his assets back. Retain the ability to get his assets back. Well, once you retain the ability to get your assets back, this is a power that you can exercise for your own benefit. And whenever you have power over a trust that you can exercise for your own benefit, your creditors can force you to exercise that power. So every single asset protection trust must be irrevocable, meaning the person who set up the trust and transferred assets to the trust has not retained the ability of getting his assets back. Now, if you think about that, that sounds like a fairly scary proposition. I transfer my assets, maybe my life savings, right, into this irrevocable trust. and I do not have the ability to get the assets back. That's scary. I mean, not a lot of people are willing to do that. Right? That's the reason why you do not see a lot of irrevocable trusts as compared to revocable trusts. But I would like to tell you that really that is not the case anymore. We are today are able to set up a revocable trust, which can be just as flexible and will allow you to retain just as much control as a trust that is revocable. So how do we do that? We do that by utilizing the mechanism of what is known as a trust protector. What is a trust protector? So customarily in a trust, you have the settlor, you have the trustee, and you have the beneficiaries. Well, for the past 7-8 years, we have been using in the United States the concept of the protector, which is a fourth party being added to the trust relationship. A trust protector is someone that we appoint a position, it's an office within the trust, and we appoint the trust protector and empower the trust protector to have certain powers that customarily have been reserved either for the trustee or simply were not reserved for anyone, which is even more common. What do I mean by that? So, for example, if I transfer assets into a trust, no one has the power to change the trustee, most commonly, right? You can have it, but most commonly, no one has the power to change the trustee. No one has the power to change the beneficiaries of the trust. No one has the power to change, the distribution scheme. So a lot of the powers that we hold over assets prior to transferring them into a trust, we lose once the assets are transferred into a trust. What the concept of the trust protector allows us to do is preserve a lot of these powers. Right? So these are not new powers that we are creating that never existed before. Simply powers that you used to have over your assets. Before you transfer the assets into the trust, we are preserving them in the trust protector. And what we usually give the trust protector are the following powers. The power to change the trustee of the trust, right? Remove and replace the trustee. The power to change the beneficiaries of the trust sometimes. The power to possibly veto distributions from being made. The power to change the governing law of the trust. To switch between grantor and non-grantor status of the trust. The power to change any provision of the trust, which is huge, right? Like complete power to amend the trust. So it may sound a little bit scary to you because, we are giving someone a lot of power over the trust. How do we know that we can rely on this person to take care of our affairs? How do we know we can rely on them to have that much power? Well, it really depends on who this person is, right? If you had to hire a complete stranger or one of those like large, bank companies to be the protector of your trust, then maybe you do not have the peace of mind to have a trust protector in your trust. But what if you could appoint a family member as a trust protector of your trust? What if you could appoint your best friend to be the trust protector of your trust? Maybe there's a little bit more trust there with you, right, to do that. And more importantly, what if you had the ability to remove this trust protector and replace them with someone else? I think that, more than anything else, gives our clients the peace of mind in utilizing this trust protector concept. This really sort of revolutionized trust law in the United States over the past 7-8 years. It's been a wildly popular concept. You see it spreading sort of like wildfire through the trust community in the U.S. It's a concept that I personally like a lot. I use it a lot because it does allow my clients to retain control over the assets they place in an irrevocable trust. I use it with my own trust. It's an absolutely wonderful concept. So we do use irrevocable trust a lot for asset protection, both for individuals and for entities. So how do I use them for entities? I have a client right now that it's a business that is a corporation. I'm not going to specify what kind of a business, and the business is slowly failing, and there are lots of creditors that this business has, and there are also some significant assets. So if the corporation files for bankruptcy, the assets will simply become part of the bankruptcy estate and will be used to pay off the business creditors. So what the client is doing is he's having his corporation settle the trust and transfer the ownership of corporate assets into a trust. I cannot discuss, since this is case specific, who the beneficiaries of the trust would be, but really there are no legal limitations on who the beneficiaries of the trust can be. It can be individuals, does not need to be a legal entity, but it also can be a legal entity if you want it to be. Obviously something other than this corporation that will be sued. And the corporation settles the trust and it no longer owns its assets. But, the client can appoint someone to be the protector of this trust and through this person retain control over the former corporate assets. So it's surprising, I think, to some people that a trust can be used to protect the assets of a business entity, but really it can be. So it's very interesting, some very creative planning. Let's talk a little bit. Let me find the slide. Let's talk a little bit about foreign trusts and just kind of offshore planning in general. So we use trusts a lot in the United States, and the vast majority of trusts we do set up for clients to protect assets are U.S.-based trusts. But sometimes we will use for a client a foreign trust. And we certainly use foreign trusts a lot for our foreign clients that we do a lot of pre-immigration tax planning work and so forth, but that's for a completely different and separate reason from asset protection. So from an asset protection standpoint, what's the advantage of a foreign trust? Well, the advantages are multifold. First of all, we are setting up these trusts in countries that have enacted very favorable asset protection laws, favorable as to debtors. Right? So they've done something with their trust laws, with their debtor-creditor laws, to make it a lot more difficult for a creditor to collect against the asset of a trust registered in that country. Probably the most famous jurisdiction in the world for an asset protection trust is the Cook Islands. The Cook Islands, I think, was the first had the first well-drafted legislation entirely focused on asset protection. It still, in my opinion, has one of the best legislations out there on foreign trusts. What makes their legislation so attractive are several provisions. The most important one is their legislation provides that when it comes to a local trust, the Cook Islands will not recognize a foreign judgment, meaning that the foreign judgment simply will not be enforceable against the assets of a trust that is registered in the Cook Islands. And if a creditor cannot enforce their U.S.-based judgment against the assets of a Cook Islands trust, what can they do? Well, can they sue our client in the Cook Islands? Probably not. There is no jurisdiction over our client in the Cook Islands. Really, the only thing they can do is either bring a fraudulent transfer lawsuit in the Cook Islands or try to somehow get the judge to issue a turnover order directed at the client here in the United States, forcing them to turn over the assets of their foreign trust. Proving a fraudulent transfer in a jurisdiction like the Cook Islands is not easy. It's a 2-year statute of limitations, and the Cooks requires the proof of a fraudulent transfer beyond a reasonable doubt. So do we use the Cook Islands for our offshore asset protection trust? The answer is we used to. We used to. When I started practicing asset protection, when there were so few other guys doing this, and no one knew what asset protection was or heard of it, we used the Cook Islands quite a bit. It was a great jurisdiction. Today, asset protection has gained a lot of notoriety as an asset protection jurisdiction, and very often our clients want to avoid that notoriety. And I'm not referring only to clients that are maybe, celebrities or just high-profile people, politicians, what have you. Even the regular Joe Schmoes may not want the world to know that they're engaging in asset protection. especially if this is in the context of litigation, you want to defend against a possible fraudulent transfer attack. If my client is facing criminal charges and does not want to make himself look like even more of a bad guy, you don't want to go to a jurisdiction like the Cook Islands because that makes it very obvious to the world what you are doing. So we go to a jurisdiction like St. Vincent and the Grenadines, actually my favorite offshore jurisdiction for foreign trusts over the past several years. The advantage of St. Vincent is that it has laws that are identical to the Cook Islands. I believe St. Vincent initially photocopied the Cook Islands trust laws, like literally, which is a much cheaper way of getting your own legislation than hiring a law firm to draft it for you. Their laws are identical. They're part of the British Commonwealth, so they have the same financial system services industry that the Cooks would have. Same very low-cost trust services that you have some big trust companies provide. And no one has ever heard of St. Vincent, certainly not as a context of asset protection. So, it's a great country to be in. If you'd like me to share with you the name of the trustee that we use in St. Vincent, or even make an introduction, I'm happy to do that. We have a great trust company there. We've been using it for quite a few years. I don't make these introductions in a public setting, but if you'd like to send me an email, I'll be happy to do that. So we like foreign trust, and the foreign trust, in my experience, from a practical standpoint, has a significant chilling effect on litigation. Most plaintiffs, most creditors, when they see that there is a foreign trust, actually when they see that there is any sort of a foreign structure, they're a lot more willing to settle, or sometimes even more willing to walk away. If you recall, I gave you an example earlier of my 74-year-old client that guaranteed the $5 million loan that her son took out. What we did with her liquid assets, she had about $4 million worth of liquid assets, is we transferred the assets into an offshore trust, and the offshore trust established a Swiss bank account where the money went. And she owed her $5 million guarantee, increased significantly by various penalties and legal fees, to one of the largest banks in the United States. And the bank simply walked away from her. They simply did not pursue her. They did not want to deal with an offshore structure. And it's a fantastic result, right? Again, it's something that we cannot guarantee to clients, but we can certainly guarantee that if she didn't try to do that, right, that result would be impossible. So offshore structures, and you can read all kinds of things about offshore structures, they tend to work really well. They don't work perfectly. One of the remedies that a very bright plaintiff, an aggressive plaintiff may pursue is to convince the judge that our client has effectively retained control over the assets in the offshore structure, and get the judge to issue to our client a turnover order saying, hey, debtor, turn over the assets to the creditor. And then if the debtor fails to do so, to hold debtor in contempt of court, and maybe using it as sort of as coercive contempt, meaning holding him in contempt until he complies. It's a very rare remedy. I've never seen it in my practice, and I think I have one of the largest asset protection practices in the U.S. But certainly there are cases out there where that has happened. We need to be mindful of that. There is a risk of that. But I think even if that does happen, if the trust is well drafted, there's always an out. There's always a way to disassemble the trust, bring the assets back, and avoid going to jail, which I think clients should avoid at all costs. There's been a lot of talk lately about whether the offshore structures have retained their efficacy given what's been going on with the Swiss banks, with FATCA, all the new disclosure regimes that are going into place across the world. And, when we have a fairly significant international practice, so we see this not just with asset protection, we see it with our business clients who simply may want to bank overseas. What FATCA and everything that happened prior to FATCA, like the UBS case and all the IRS offshore voluntary disclosure programs, what they have done is they initially sort of placed a chilling effect on offshore asset protection planning because clients simply reading newspaper articles were scared of doing something overseas because they had this perception that anything you do overseas is illegal. And that sort of went away because people realized, well, it's not illegal to do things overseas. It's simply illegal not to disclose it if you have to. Our clients do not go overseas because they're looking to avoid the tax man, right? They're looking to protect their assets from claims of creditors. So I think there's absolutely no reason why our clients cannot set up offshore structures, disclose whatever they have to disclose to the IRS, disclose their foreign bank accounts, disclose their foreign trust, foreign entity. Usually tax returns, well, I guess it varies from state to state, but usually tax returns are privileged and not available to plaintiffs and creditors. But even if they are, these structures work really well, even if the plaintiff knows exactly where the money is at, far, far, far overseas. Let's talk a little bit about, I'll go for another maybe 3-4 minutes, and then we'll open it up for questions. Let's talk a little bit about retirement plans. So retirement plans, both for our individual clients and for business entities, are usually kind of the more significant assets. So what is the protection afforded to retirement plans? And I'm actually dealing with this right now where a client has millions of dollars in a retirement plan and facing some significant creditor challenges. The question is, are the assets of this retirement plan protected? Well, the answer is it depends, right? Very lawyerly answer. It depends. What does it depend on? It depends on two things. It depends on whether the plan is ERISA qualified or it's not ERISA qualified, and if it's not ERISA qualified, which state you are in. So if we have an ERISA qualified retirement plan, like a 401k plan, a profit sharing plan, a defined benefit plan, anything that's ERISA qualified, so long as you have at least one employee vested in this plan, and this employee must be someone other than the owner of the business, then under federal law, the assets of the plan are not available to creditors, to any third-party creditors. So I think this was made sort of famous in the O.J. Simpson case, the fact that the Goldman family and the Brown family was not able to reach his NFL pension plan and the 401k plan he had in his own entertainment corporation. To us who practice in this area, it's even more famous. It was made even more famous by the Guidry case, which is a Supreme Court case from about 7-8 years ago, where a union official embezzled money from the union, took the money that he embezzled, contributed it to his 401k plan. The union tried to get the money back, and they were unsuccessful, with the Supreme Court holding that only the plan participant can reach the assets of a retirement plan. So literally, you can rob a bank, run across the street to your plan administrator's office, contribute the money to the plan, and the bank will not be able to get it back. So very, very strong asset protection. But that's for an ERISA qualified plan where you have at least one employee vested in the plan. What about plans that are not ERISA qualified? And the most common type of a retirement plan that is not ERISA qualified is an IRA. Any type of an IRA, SEP, Roth, whatever. So now we look at state law, and there is no federal law protection. And under state law, whether there is protection or not depends on the state you're in. Right? This is now, you find this protection in your state's exemption statutes, and they will provide to what extent retirement plans are protected. So, for example, if you're in Florida or if you are in New York, your retirement plans are protected without a limitation, period, regardless of the kind of plan you have. If you are in Nevada, $500,000 is protected in a retirement plan. If you're in California, well, you're out of luck because California uses a subjective standard, same standard that's used in bankruptcy law, that assets of a retirement plan are protected only to the extent reasonably necessary for retirement needs, which is a very vague and unfriendly standard to debtors. Okay,